Title II. Incorporation and Organization of Private Corporations. Section 10. Number and qualifications of incorporators. Any number of natural persons not less than 5, but not more than 15, all of legal age and a majority of whom are residents of the Philippines, may form a private corporation for any lawful purpose or purposes. Each of the incorporators of S stock corporation must own or be a subscriber to at least 1 share of the capital stock of the corporation. 6a. Section 11. Corporate term. A corporation shall exist for a period not exceeding 50 years from the date of incorporation unless sooner dissolved or unless said period is extended. The corporate term as originally stated in the Articles of Incorporation may be extended for periods not exceeding 50 years in any single instance by an amendment of the Articles of Incorporation, in accordance with this code, provided that no extension can be made earlier than 5 years prior to the original or subsequent expiry date, unless there are justifiable reasons for an earlier extension as may be determined by the Securities and Exchange Commission. 6. Section 12. Minimum capital stock required of stock corporations. Stock corporations incorporated under this code shall not be required to have any minimum authorized capital stock except as otherwise specifically provided for by special law, and subject to the provisions of the following section. Section 13. Amount of capital stock to be subscribed and paid for the purposes of incorporation. At least 25% of the authorized capital stock as stated in the Articles of Incorporation must be subscribed at the time of incorporation, and at least 25% of the total subscription must be paid upon subscription, the balance to be payable on a date or dates fixed in the contract of subscription without need of call, or in the absence of a fixed date or dates, upon call for payment by the Board of Directors, provided, however, that in no case shall the paid-up capital be less than 5,000 P5,000.00 pesos. N. Section 14. Contents of the Articles of Incorporation. All corporations organized under this code shall file with the Securities and Exchange Commission Articles of Incorporation in any of the official languages duly signed and acknowledged by all of the incorporators, containing substantially the following matters, except as otherwise prescribed by this code or by special law. 1. The name of the corporation. 2. The specific purpose or purposes for which the corporation is being incorporated. Where a corporation has more than one stated purpose, the Articles of Incorporation shall state which is the primary purpose and which are the secondary purpose or purposes, provided that a non-stock corporation may not include a purpose which would change or contradict its nature as such. 3. The place where the principal office of the corporation is to be located, which must be within the Philippines. 4. The term for which the corporation is to exist. 5. The names, nationalities, and residences of the incorporators. 6. The number of directors or trustees, which shall not be less than 5, nor more than 15. 7. The names, nationalities, and residences of persons who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified in accordance with this code. 8. If it be a stock corporation, the amount of its authorized capital stock in lawful money of the Philippines, the number of shares into which it is divided, and in case the share are par value shares, the par value of each, the names, nationalities and residences of the original subscribers, and the amount subscribed and paid by each on his subscription, and if some or all of the shares are without par value, such fact must be stated. 9. If it be a non-stock corporation, the amount of its capital, the names, nationalities, and residences of the contributors and the amount contributed by each, and 10. Such other matters as are not inconsistent with law and which the incorporators may deem necessary and convenient. The Securities and Exchange Commission shall not accept the articles of incorporation of any stock corporation unless accompanied by a sworn statement of the treasurer elected by the subscribers showing that at least 25% of the authorized capital stock of the corporation has been subscribed, and at least 25% of the total subscription has been fully paid to him in actual cash and / or in property the fair valuation of which is equal to at least 25% of the said subscription, such paid up capital being not less than 5,000 P5,000.00 pesos. Section 15. Forms of Articles of Incorporation. Unless otherwise prescribed by special law, Articles of Incorporation of all domestic corporations shall comply substantially with the following form. Articles of Incorporation. Of. Name of corporation. Know all men by these presents. The undersigned incorporators, all of legal age and a majority of whom are residents of the Philippines, have this day voluntarily agreed to form a stock, non-stock, corporation under the laws of the Republic of the Philippines. And we hereby certify. First, that the name of said corporation shall be, Inc. or Corporation. Second, that the purpose or purposes for which such corporation is incorporated are, if there is more than one purpose, indicate primary and secondary purposes. Third, that the principal office of the corporation is located in the city/municipality of, province of, Philippines. Fourth, that the term for which said corporation is to exist is years from and after the date of issuance of the certificate of incorporation. Fifth, that the names, nationalities, and residences of the incorporators of the corporation are as follows. Name, nationality, residence. Sixth, that the number of directors or trustees of the corporation shall be, and the names, nationalities, and residences of the first directors or trustees of the corporation are as follows. Name, nationality, residence. Seventh, that the authorized capital stock of the corporation is, pesos in lawful money of the Philippines, divided into shares with the par value of pesos per share. In case all the share are without par value. That the capital stock of the corporation is shares without par value. In case some shares have par value and some are without par value, that the capital stock of said corporation consists of shares of which shares are of the par value of pesos each, and of which shares are without par value. Eighth, that at least 25% of the authorized capital stock above stated has been subscribed as follows. Name of subscriber, nationality, no of shares. Subscribed amount. Subscribed. Ninth, that the above-named subscribers have paid at least 25% of the total subscription as follows. Name of subscriber, amount subscribed, total paid in. Modify NOS 8 and 9 if shares are with no par value. In case the corporation is non-stock, NOS 7, 8 and 9 of the above articles may be modified accordingly, and it is sufficient if the articles state the amount of capital or money contributed or donated by specified persons, stating the names, nationalities, and residences of the contributors or donors and the respective amount given by each. 10th, that has been elected by the subscribers as treasurer of the corporation to act as such until his successor is duly elected and qualified in accordance with the bylaws, and that as such treasurer, he has been authorized to receive for and in the name and for the benefit of the corporation, all subscription, or fees, or contributions or donations paid or given by the subscribers or members. 11th, corporations which will engage in any business or activity reserved for Filipino citizens shall provide the following. No transfer of stock or interest which shall reduce the ownership of Filipino citizens to less than the required percentage of the capital stock as provided by existing laws shall be allowed or permitted to be recorded in the proper books of the corporation, and this restriction shall be indicated in all stock certificates issued by the corporation. In witness whereof, we have hereunto signed these articles of incorporation, this day of, 19 in the city/municipality of, Province of Republic of the Philippines. Names and signatures of the incorporators. Signed in the presence of Notarial Acknowledgement. Treasurer's Affidavit. Republic of the Philippines. City/Municipality of SS. Province of I, being duly sworn, depose, and say that I have been elected by the subscribers of the corporation as treasurer thereof, to act as such until my successor has been duly elected and qualified in accordance with the bylaws of the corporation, and that as such treasurer, I hereby certify under oath that at least 25% of the authorized capital stock of the corporation has been subscribed and at least 25% of the total subscription has been paid, and received by me, in cash or property, in the amount of not less than P5,000.00, in accordance with the Corporation Code. Signature of Treasurer. Subscribed and sworn to before me, a notary public, for and in the city/municipality of province of, this day of, 19, by with res. Cert. No. Issued at on 19. Notary public. My commission expires on, 19. Doc. No. Page no. Book no. Series of 19, 7A. Section 16. Amendment of Articles of Incorporation. Unless otherwise prescribed by this code or by special law, and for legitimate purposes, any provision or matter stated in the Articles of Incorporation may be amended by a majority vote of the Board of Directors or Trustees and the vote or written assent of the stockholders representing at least two-thirds of the outstanding capital stock, without prejudice to the appraisal right of dissenting stockholders in accordance with the provisions of this code, or the vote or written assent of at least two-thirds of the members if it be a non-stock corporation. The original and amended articles together shall contain all provisions required by law to be set out in the Articles of Incorporation. Such articles, as amended, shall be indicated by underscoring the change or changes made, and a copy thereof duly certified under oath by the corporate secretary and a majority of the directors or trustees stating the fact that said amendment or amendments have been duly approved by the required vote of the stockholders or members, shall be submitted to the Securities and Exchange Commission. The amendments shall take effect upon their approval by the Securities and Exchange Commission or from the date of filing with the said commission if not acted upon within 6 months from the date of filing for a cause not attributable to the corporation. Section 17. Grounds when articles of incorporation or amendment may be rejected or disapproved. The Securities and Exchange Commission may reject the articles of incorporation or disapprove any amendment thereto if the same is not in compliance with the requirements of this code, provided that the Commission shall give the incorporators a reasonable time within which to correct or modify the objectionable portions of the articles or amendment. The following are grounds for such rejection or disapproval. 1. That the articles of incorporation or any amendment thereto is not substantially in accordance with the form prescribed herein. 2. That the purpose or purposes of the corporation are patently unconstitutional, illegal, immoral, or contrary to government rules and regulations. 3. That the treasurer's affidavit concerning the amount of capital stock subscribed and/or paid is false. 4. That the percentage of ownership of the capital stock to be owned by citizens of the Philippines has not been complied with as required by existing laws or the Constitution. No articles of incorporation or amendment to articles of incorporation of banks, banking, and quasi-banking institutions, building and loan associations, trust companies, and other financial intermediaries, insurance companies, public utilities, educational institutions, and other corporations governed by special laws shall be accepted or approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency to the effect that such articles or amendment is in accordance with law. N. Section 18. Corporate name. No corporate name may be allowed by the Securities and Exchange Commission if the proposed name is identical or deceptively or confusingly similar to that of any existing corporation or to any other name already protected by law or is patently deceptive, confusing or contrary to existing laws. When a change in the corporate name is approved, the Commission shall issue an amended certificate of incorporation under the amended name. N. Section 19. Commencement of corporate existence. A private corporation formed or organized under this code commences to have corporate existence and juridical personality and is deemed incorporated from the date the Securities and Exchange Commission issues a certificate of incorporation under its official seal, and thereupon the incorporators, stockholders/members and their successors shall constitute a body politic and corporate under the name stated in the Articles of Incorporation for the period of time mentioned therein, unless said period is extended or the corporation is sooner dissolved in accordance with law. N. Section 20. De facto corporations. The due incorporation of any corporation claiming in good faith to be a corporation under this code, and its right to exercise corporate powers, shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding. N. Section 21. Corporation by estoppel. All persons who assume to act as a corporation knowing it to be without authority to do so shall be liable as general partners for all debts, liabilities, and damages incurred or arising as a result thereof, provided, however, that when any such ostensible corporation is sued on any transaction entered by it as a corporation or on any tort committed by it as such, it shall not be allowed to use as a defense its lack of corporate personality. On who assumes an obligation to an ostensible corporation as such, cannot resist performance thereof on the ground that there was in fact no corporation. N. Section 22. Effects on non-use of corporate charter and continuous inoperation of a corporation. If a corporation does not formally organize and commence the transaction of its business or the construction of its works within 2 years from the date of its incorporation, its corporate powers cease and the corporation shall be deemed dissolved. However, if a corporation has commenced the transaction of its business but subsequently becomes continuously inoperative for a period of at least 5 years, the same shall be a ground for the suspension or revocation of its corporate franchise or certificate of incorporation. 19a. This provision shall not apply if the failure to organize, commence the transaction of its businesses or the construction of its works, or to continuously operate is due to causes beyond the control of the corporation as may be determined by the Securities and Exchange Commission.